Yes, good morning to everybody. Welcome to the today's class. Yes, today's class is the interpretation of the statutes, and I already made it that I am going to deal today the Mischief Rule. That is the point of view today's class. Yes, I hope that you are hearing me, isn't it? If the answer is yes, you please say yes. So you are hearing me. Say yes. Are you hearing me? Say yes if you are hearing me.
సార్ వినిపిస్తుంది సార్.
మరి ఇంతసేపా అండి చెప్పడానికి ఇంతసేపా ఓకే రీడ్ వాట్ ఈస్ దేర్ ఆన్ ద screen because I use the Latin phrases in this today's posting and where we used ad hoc, ipso facto, circa, de facto, ergo, etc. In fragmento delicto, vox populi, terra cognita, status quo, pro bono, per se, mi sipla. It is mi sipla, mi culpa, ipso facto. Out of them, how many that you know it? Because you are using it two times. Kannaboina, Usharani, the two times that you are, I could see you. Anyway, that no matter, right? The two times are there. Okay. Yes, now you tell me that, did you know that these, what I posted there on the screen, did you know before? If you know, how many that you know before? Just unmute and give me the answer. Unmute and give me the answer. Yes, speak. I could not hear a sound. It's okay, but anyway, that you read it and you know, understand when it can be used, when it cannot be used. This thing that you could understand it. And ad hoc means ad hoc appointment. We will say for the purpose only. Oh, what is that? Whether it is a regular appointment or ad hoc appointment? Means we will say the ad hoc appointment. We will say ipso facto means from the beginning. By the very facto, it is wrong. And the carpa diem means seize the day. Suppose the day will be seized over there at the time the karpa day we can say me kalpa means it's my fault and circa means around or approximately circa that per se means thought itself that will say the battery or assault actionable per se we will say and de facto in fact we will say de facto and de jure also we will use pro bono in the sense done without charge that we can say pro bono and ergo therefore the status quo should be maintained that we will say in another way this is the status quo then we'll say etc yes etc etc that and others and etc if another thing will be there then we will say the extra will come follows then we use the etc let me say pen pencil rubber scale etc means whatever the thing which is used for writing it can be used with the other things terra terra incognita in the sense unknown land because if the land is unknown we can say unknown land we will say that is a terra incognita and in flagrante delicto the act of committing a crime. Yes, this is the act also say that the act of committing a crime and works properly the voice of the people. So these are the terminology generally that we will use in your study, in your discussion, in the argument also, in the case writing also, in the legal profession. So that's why I thought that it may be useful to the students with that view. I posted it. So this is about the today's my posting is concerned. Again, we are discussing the three rules which are basically in the need. The number one is the literary rule. In other words, we can say it is a grammatical rule. In other words, that we can also say it is the plain meaning rule. Then the second one we will say that it is a golden rule that we are using it. Yes, the cases also we dealt yesterday class, online class, and today class that the mischief rule that is that we are going to study in this class. Yes. Let us see that what this mischief rule says. This rule gives the judges the most discretion of all. There is the four principles to follow were expressed in the Haydn's case. The mischief rule also can be known as the Haydn's case, and this rule uh, will be known as a hidden case. What I want to say is, which concern the conflict over the legal action against the hidden. Here, the hidden rule says the mischief rule can also be said as a hidden rule. Yes, and these rule says the 5 points for the hidden rules. And the 5 points, let me see that when we can use this rule. What was the common law before the making of the act? So that is the first question. What was the common law practice would be there before making this act, if any act would be come into force? The second point is, what was the mischief and defect for which common law did not provide? So the common law would not provide it. What is that defect? We will see it when the act was there and defect is not covered over there. Then the third point is, what remedy Parliament has resolved and appointed to cure the disease of the Commonwealth. So, what would be the thinking of the Parliament to remove such a defect? And the last one is the true reason for the remedy. Then the office of the judges to make such a construction as shall suppress the mischief and advance the remedy. That is the gist of it. Suppress the mischief and advance the remedy is the outcome of this mischief rule. Yes, then we will see what are the cases would be there under the mischief rule and when we can use them this mischief rule. And before I could go further, I would like to ask, do you want any clarification in this regard or not? Yes, I could saw that Sheshavatam is very much present, Kannabena Sharan is very much present. Yes, the other people may join. And yes, now you can speak. Yes.
So please repeat. So please repeat this, sir. Please repeat this one.
It is nothing but the earlier rule. First rule is the grammatical rule, and where we say the plain meaning rule, or we can say the linear rule. The second is the golden rule, and the third is the mischief rule. The third mischief rule, which is said to be as a Haydn's rule, but this mischief, what is the actually mischief is there? The common law practice would be there. Suppress the mischief and give the remedy. That is the gist of this rule. I repeat, suppress the mischief and give the remedy. That is the gist of this rule. So, this rule also can be ruled as a Haydn's rule. A Haydn's rule in one way, in another way, we can say in this. Suppose we are not supposed to kill the birds if the act is came over there. When the act itself say killing is inhuman activity, either the bird is concerned or the chicken is concerned or human being is concerned. When killing is an inhuman activity, then the law is passed. You are not supposed to kill the bird. Does it mean that you can kill the human being?
You cannot.
The reason is we are not supposed to even to kill the bird means we are not supposed to harm the body. Either is an animal or a bird or a human being. When a bird body could not be harmed over there, then how could you expect that the human body would be killed or human body will be destroyed or human body would be injured? So that is suppress the mischief and get the remedy for that one. That is the actual gist of this rule is concerned. So if you see one of the case law, you will understand how we can suppress and how we can give the remedy will come out. For instance, you say Smith versus Sachs case law is in 1960. The defendant were charged under Street Offence Act. This already we discussed. Where can you tell me that I told you prostitutes on the streets, they are standing, where they are standing, these prostitutes. Yes, anyone? See, we discussed this case law several times. The law says clearly, the prostitute should not entice or solicit by standing on the street, or on the street, or in the street, or on the road. So these prostitutes, what they did it, they are sitting in their balcony, they are looking or peeping through the windows, or they are standing on the threshold of their door and tapping the door and making the sounds and attracting the passerbys for their flesh trade. What is the synonym for the prostitutes? వాట్ ఈస్ ద సినానిమ్ ఫర్ ద ప్రాస్టిట్యూట్స్? తెలిసిన చేయలేకుండా పాస్ ఆన్ అని చెప్పండి, నేను చెప్పేస్తా.
Pass on, pass on.
ఎస్, వై యు ఆర్ టేకింగ్ దట్ మచ్? ప్రాస్టిట్యూట్స్ ని ఏమంటారంటే ఇంకొక విధంగా కాల్ గర్ల్ కూడా అంటారు, ఫ్రస్ట్రేట్ గర్ల్ కూడా అంటారు, హార్లాట్, HARLOT, హార్లాట్ కూడా అంటారు, WHORE కూడా అంటారు, చిప్పి, CHIPPY, చిప్పి కూడా అంటారు. కనీసం నేను చెప్పిన ఒక 2-3 అనే చెప్పండి ఇప్పుడు. సార్ అంత తొందరగా గుర్తుపెట్టుకోలేము సార్. ఎస్, సే ఎస్ ఆర్ నో.
Call girl, call girl.
ఇంకా ఇంకా చెప్పండి.
From the
ఇక్కడ
beginning we could-
ఇక్కడ చూపెట్టాను, చూడండి సినానిమ్స్ ఫర్ ద ప్రాస్టిట్యూట్ చూపెట్టాను, కనబడుతుందా లేదా?
Bard, call girl, hookety, partisan, grab, hooker, still. Sex worker, yes, that we know, sir. Sex workers, street walker, and tart.
TART, టార్ట్, నాట్ TORT.
Tart.
ఓర్, WHORE, హార్లాట్, HARLOT, చిప్పి,
So
ఫ్లూజీ, ట్రాంప్,
we know only. We only
జేడ్, కొకెటే, ఫ్లిట్, సిరెన్, టెంపర్, టెంపరెస్, వ్యాంప్. వ్యాంప్ అంటారు, వ్యాంప్ చూసినాం, VAMP, వ్యాంప్. సో దీస్ ఆర్ ఆల్ ద అదర్ నేమ్ ఫర్ ద ప్రాస్టిట్యూట్స్, ఉమెన్ ఆఫ్ ది స్ట్రీట్. అగ్రీడ్? నౌ యు గాట్ ఎట్ లీస్ట్ సమ్ ఆఫ్ ది న్యూ. ఏం సార్ మంచి నేర్పంటే ఇవన్నీ నేర్పిస్తాను ఏంటి సార్ అంటే ఏమంటారు తెలుసుకోండి అంటాను నేను. ఆర్ యు ఫాలోయింగ్ మీ?
Of course,
Say yes. Yes. Now the prostitutes are not standing on the street, not standing on the road, not standing on the street, but they are standing on their balconies. They are standing in their doors, and by making the sound, drawing the attention of the passerbys, and they want to entice them, solicit them. Kabatti, ఇది వాళ్ళకు అప్లికబుల్ అవుతుందా కాదా ప్రాస్టిట్యూట్స్ కి చెప్పాలా?
mischief.
వాళ్ళు ఏమన్నారు? రోడ్డు మీద ఉండి మీరు వాళ్ళను ఎంటైజ్ చేయొద్దు అన్నారు. మేము రోడ్డు మీద లేవు కాదు సార్, మేము ఇంట్లో ఉన్నాం కాదు సార్ అంటే అర్థం అంటే మీరు రోడ్డు మీద ఉండి ఎంటైజ్ చేసిన, మీ బాల్కనీ నుండి ఎంటైజ్ చేసిన, by threshold, by standing on the threshold also you are enticing them, soliciting them. The soliciting is there is the more appropriate word. So that is more appropriate, soliciting, rather than the standing on the street is mischief is removed and the remedy is outlated. Remedy ఏంటి ఇక్కడ? soliciting. అంతేనా అండి? చెప్పండి.
Not a
స్టాండింగ్ ఈజ్ ద మెయిన్ పాయింట్, ఎంటైసింగ్ ద మెయిన్ పాయింట్ ఇక్కడ.
standing is the main point.
స్టాండింగ్ అంటే వాళ్ళు బాల్కనీలో ఉన్నారు కదండి, స్టాండింగ్ ఎందుకు మెయిన్ పాయింట్ అవుతుందండి? స్టాండింగ్ కాదు కదండి, వాళ్ళు బాల్కనీలో ఉన్నారు కదా.
Balcony. Standing in the balcony. Yeah.
Either you standing on the road, you standing on the balcony, you are standing on the threshold, you are standing inside, doesn't matter where you are standing. What are you doing is more important, that is enticing and soliciting. Kabatti, mischief rule is applied here and the mischief is suppressed and remedy is taken. The remedy is soliciting here. So soliciting is the more important factor here. Kabatti, the mischief rule was applied to interpret that the prostitutes were doing what the statute was trying to abolish, so they were convicted. Do you want any more explanation?
No, sir.
See, whether you stand on the street, whether you stand in the street, wherever you stand, doesn't matter. But your act is more countable there. That is enticing and soliciting. So, sir, we are not standing on the street and we are not enticing them. You cannot say. Either you enticing them, soliciting them from your house or windows or balconies. Enticing is and soliciting is more important. Hence, mischief rule is applied over there. and the remedy is given over there. The importance is given not understanding, the importance is given on the enticing or soliciting. That is the more important factor. So that is the very, very important factor here, but not the other factor. Is it clear?
Yes, sir. Yes, sir.
ఇప్పుడు వాసన వస్తాందిరా బాబు, అవన్నీ వదిలిపెట్టి రారా అని చెప్పిండు వారికి. అసలు అర్థం ఏంటిదండి? ఆ వాసన రావద్దనే కదా అని.
జేబులు పెట్టుకొని కాదు.
జేబులు పెట్టుకునేదే కాదు కదా.
కాదు కాదు.
మరి పార్లమెంటరీ వాట్ సేస్ అనేది లిటరరీ ఇంటర్ప్రిటేషన్ లో చూసినాం, పార్లమెంట్ వాట్ సేస్ అనేది గోల్డెన్ ఇంటర్ప్రిటేషన్ చూసినాం. కానీ మిచీఫ్ ఇంటర్ప్రిటేషన్ లో ఏం చూస్తాను? వాట్ యు ఆర్ లుకింగ్ ఇట్, వాట్ ఈజ్ మెంట్, మెంట్ చూస్తాను. అంటే అర్థం అసలు అది చెప్పడానికి దాని అవుట్కమ్ చూస్తాను ఇక్కడ.
అంతే అంతే.
ఇప్పుడు అవుట్కమ్ వాసన కదండి ఎక్కడ.
అవును.
మరి ఇక్కడ అవుట్కమ్ ఏంటండి? ఎంటైసింగ్ కదండి,
అంతే అంతే సార్.
సాలిసిటింగ్ కదా. ఎక్కడికి వెళ్ళి ఉండానది కాదు కదా పాయింట్.
కాదు సార్.
సో హియర్ ద మిచీఫ్ ఈజ్ suppressed and remedy is taken over there. Hence, the prostitutes or harlot or whore or chubbies or streetwalkers or women walkers or call girls were punished or convicted under the Street Offences Act of 1959. So now let us see. The golden rule is used to handle the dispute. And ఈ విధంగా గోల్డెన్ రూల్ చూసుకుంటే ఏంటంటే కొంచెం స్ట్రెచ్ చేస్తాం మీనింగ్ ని, ఇందులో మాత్రం అవుట్కమ్ చూస్తున్నాం కాబట్టి అవుట్కమ్ the total outcome you will చూస్తున్నాం కాబట్టి hence it will be the Mischief rule be used over there in this case law. Your people making the sounds, so I muted them. Yeah, so that is the actual point. Let us see the next case law. Next case చూద్దాం. ఇప్పుడు అబోర్షన్ ఉన్నది. అబోర్షన్ ఎవరు చేయొచ్చండి? Yes, only a licensed doctor could operate abortion provided that mother life is more important than the child in the womb. Hence, they can abort the fetus. Can a nurse will do?
No, sir.
Yes, nurse can do. Only the doctor will operate. The doctor presence, he will say something. Then the nurse will help the doctor to do the abortion.
The medical doctor only can do.
Kapoted nurse చేసింది అనుకోండి, nurse became so much expert than the doctor. Can the nurse will eligible for the abortion, to do the abortion?
Not officially.
Not officially కాదు, చేయొద్దు. That will be a point. It will be a crime also, even though she is more expert than the doctor. But the presence of the doctor is must. Then what is going on and ఎవరు చూడరు కదా, only medical staff will do it. Do they allow you to be in the theater?
No, sir.
Only the medical practitioners, or if you are a doctor, if you yourself also a doctor, okay, you will be allowed over there to see it and to guide it. Suppose if you are an expert and your hand will shiver it, that's why you are asking another doctor to do it. So now the comes over there, here in the Royal College of Nursing and versus DHSS lo kuda, the RCN, the Royal College challenged the involvement of nurses in the abortion. If the nurse himself or herself does it, then it cannot be possible, but it can be done only by the medical practitioner who is licensed to do so, and that to be on the medical ground. That to be on medical ground he can do so, otherwise he cannot abort it. Sir, అమ్మాయి ఉన్నది కాబట్టి అబోర్షన్ చేపిస్తాం, no question of abortion. He will not do it. Suppose if any doctor did so, then his license will be cancelled and a disciplinary action will be taken against him or her. So the main advantage of the Mischief rule is that closes the loopholes in the law and allows the law to develop. The main disadvantage is that creates a crime after the event has taken place, which can be seen in the Smith versus Sachs. Actually, we want to stop the crime. So that's why Smith versus Sachs, from where they are standing is not the point. From whether they are doing the enticing or soliciting the customers or not, that is more important factor. Hence, Mischief rule can be used over there. So this is the one of the example. Then we will see the another cases where the other example what they say. So now we will see the Elliott versus Gray. This is another case law. The defendant car was parked on the road. Okay, car park చేసి ఉన్నది రోడ్ మీద. Okay, very and good. It was jacked up and had its battery removed. దాన్ని జాక్ కూడా పెట్టేశారు, బ్యాటరీ రిమూవ్ చేశారు. వెల్ అండ్ గుడ్. He was charged with an offense under the Road Traffic Act of 1930 of the using an uninsured vehicle on the road. The defendant argued was using the car on the road as it is was not a drivable. అయితే వీడైంది, దానికి బ్యాటరీ లేదు, దానికి జాక్ వేస్తున్నది, యూజింగ్ అంటాడు. ద యూజింగ్ అనేది కాబట్టి ట్రాఫిక్ రూల్ కింద నేను రాను అంటాడు ద పర్సన్. బట్ ద కోర్ట్ హెల్డ్, వై డిడ్ యూ కీప్ సచ్ ఏ పార్క్? మీరు పార్క్ చేసినప్పుడు ఏం చేయాలా? యూ టు టేక్ ఆల్ ద ప్రికాషనరీ మెథడ్స్ లైక్ దట్. ద బ్లింకింగ్ షుడ్ బి దేర్, the caution board should be there. Either you can say that the car is in repair, or car is broke down, and they have to keep some barricades over there so that the people will understand there is something is going to happen. Otherwise, if you are stopped the car on the highway or on the road, then you will be booked under the Traffic Rule Act of 1930. The court applied the Mischief Rule, held that the car was being used on the road as it represented a hazard, and therefore insurance would be required to even the event of an incident. Even the insurance should be also be there, then only the car should be on the road. Otherwise, if the insurance is not there, you are not supposed to keep the car on the road. Any explanation do you need?
No, sir.
The reason is, when the car is not insured, number one, when the car is broken down, number two, then you have to take the procedure. Like suppose if the running car broke down, how you run the car when it is not insured? Why did you bring the car on the road? The law says you are not supposed to bring your vehicle on the road unless until you pay the insurance, because if any accident happen, who will be responsible? If any third party insurance is there, third party will claim it. If the comprehensive insurance is there, you will get the damage to the car, and you yourself is damaged or injured, or the third person injured, and everyone will get the damages. Any question?
No, sir.
Very good. So that is the case law. Here you cannot say దానికి బ్యాటరీ లేదు కాబట్టి ఏమన్నా సార్ అది యూజింగ్ అది కాదు కదా సార్. నో, వెదర్ ద బ్యాటరీ ఇస్ దేర్, వెదర్ రిమోట్ ఈస్ దేర్, ఇట్ ఈస్ సెట్ టు బి దేర్ ఆన్ ద రోడ్, అండ్ వితౌట్ ఇన్సూరెన్స్ దట్ యూ విల్ బి హెల్డ్ లయబుల్ అండర్ ద రోడ్ ట్రాఫిక్ యాక్ట్. సార్ హెల్మెట్ పెట్టుకోకపోతే పట్టుకుంటారు, మాస్క్ పెట్టుకోకుండా పట్టుకుంటారా? ఇఫ్ ద రూల్ ఈస్ దేర్, ఎస్. కానీ కార్లో పెట్టినప్పుడు మాస్క్ పెట్టుకోవద్దు. దెన్ వాట్ అబౌట్ ద టూ వీలర్?
We have to.
We have to. It is a must. So the law prohibit, when you are driving, you are not supposed to speak on mobile. ఏమైతుందని మాట్లాడితే?
You will dash to other person.
Not only dash to other person, the possibility that you will die and you will make others to die. Number two. Number three, you will be penalized. You will be fined.
Safety of others.
You will be fined.
Find.
Yes, challan would be comes to you, and you have to pay the fine. Yes, that is the point, because the law says like that. Now you will see the Corkery versus Carpenter. This is another case law. What it says? What is the name of the case law?
Fine पे करते साहब.
Pardon?
इन्होंने जिंदा कर, जो जिंदा है तो फाइन देता, नहीं तो क्या देता उन्हें कुछ नहीं.
కూర్చునే చేత వాళ్ళ నాయన ఇయ్యాలా, వాళ్ళ అవ్వ ఇయ్యాలా, వాళ్ళ అమ్మ ఇయ్యాలా, వాళ్ళ కొడుకు ఇయ్యాలా ప్రాపర్టీ నుండి.
దీని కూడా సార్, దీని కూడా సార్.
ఇప్పుడు వాడు చచ్చిపోయింది అనుకోండి, వాడు ఊకుంటాడండి? దే విల్ ఫైల్ ఏ కేసు.
సార్ లా విల్ నాట్ అప్లికబుల్.
Why not applicable? Is everything will be applicable, because when he was driving the car and he was speaking, or while he was driving the motorbike, he was speaking on the mobile. With that accident happened over there, he himself is died, and the other person who is the passerby, he got injured. And when he filed a case, అరే సచ్చినోడే వాడు పోయింది కదా కాబట్టి మరి ఇయ్యం పైసలు అంటే ఊకుంటారా అండి మీరు?
సార్ యాజ్ పర్ యాక్ట్ ఓన్లీ ఓనర్ ఈజ్ లయబుల్ నో సార్.
Whoever used the car,
MATO case.
whoever used the car, MV Act will be applicable.
Oh, sir, if owner is driving the car, he met with an accident, he died, making endangering the safety of others,
If anyone died, no matter, other injured party definitely will be compensated.
By whom, sir?
Insurance company. Why the insurance company is there?
I think that the third party insurance says that definitely the insurance company will come into picture. It will pay. No
No.
problem.
Okay.
There is no insurance. There is no insurance to car. The owner has made the accident. The other fellow died. Even himself also died. The owner of the vehicle also. There is no
From the
insurance.
property of the deceased, the compensation will be paid.
Oh, that is there. Huh? Okay.
What is there? What is there? It should be. అరే మా నాయన చచ్చిపోయిండు యాక్సిడెంట్ చేసిననే చచ్చిపోయిండు మేము ఇస్తాం పైసలు మా దగ్గర పైసలు లేవు మరి ప్రాపర్టీ ఎవరిదిరా అది మా నాయనది అమ్మి అమ్మి yes
Owner is liable in that way.
in any case even though he died so now because when a person is getting the benefit of it he has to face the its disadvantage or the debts also. So the Karkari versus Carpenter case, the defendant was riding his bicycle whilst under the influence of alcohol. Section 12 changes the Licensing Act of 1872 made it an offense to be drunk in charge of a carriage అన్నది ఇక్కడ మరి క్యారేజ్ అన్నప్పుడు సైకిల్ క్యారేజ్ కింద వస్తుందా రాదా
రాదు సార్
అయితే వాడు వదిలిపెట్టా అంటే వాడు తాగి నడుపుకోవచ్చు సైకిల్
సార్ క్యారేజ్ పోలేదు there is no any this thing for clean rider.
So one can by full drunken stage he can ride the bicycle
Definitely, sir.
and you will not be penalized.
Will not be, sir.
You will be penalized if you are even dragging the vehicle or your bicycle and going on the road or no bicycle you are drunken state you are going and you will be penalized.
Cycle is not mechanical driven, sir.
The reason is you are endangering other people, you are endangering yourself also. So now bicycle, even though it is not a carriage, but the court applied the Mischief rule holding that riding a bicycle was within the Mischief Act and the defendant represents the danger to himself and other road users. Even though you are using the bicycle, you will come under the act.
Sir, one doubt.
Yes.
Bicycle is not included under MV Act, sir.
I agreed.
Then
Next.
how can we include that in the penalty list?
The bicycle is carrying you. The bicycle is carrying you.
No mechanical driven.
Automatically, even though it is not motor driven, your pedaling is there. But the only point is your drunken state. At that instance, you cannot say that my bicycle will not come under the definition of the carriage. So mischief will be suppressed and remedy will be taken out. And they say either use the bicycle or use the tricycle or you will be on foot also. Doesn't matter. So the law says you are drunken state, you should not supposed to be on the road because you endanger yourself and you will endanger the other people also. So hence, even though bicycle is not a carriage, the mischief rule can be applied over there because riding a bicycle was within the mischief that it is carrying you and hence it will come under the definition of the carriage even though it is not a carriage in the strict sense. When the plain meaning is used over there, it is not a carriage. But the mischief rule is used over there, it is also come under the definition of the carriage, and hence under the mischief rule, you will be held liable under the Act of the Licensing Act of 1872. Any doubt?
Crockery versus Carpenter.
Yes, Crockery versus Carpenter. Any doubt?
No doubt at all, sir.
Yes. So now
KB 102, right?
Yes. Ranjit Udeshi versus State of Maharashtra. This already we discussed this case law. Lady Chatlier's lover case law. The pornography there in the book. And he was selling the book, which is banned to sell the lady Chatterley's lover. Like Satanic verses written by
Salman Rushdie.
Salman Rushdie, Lajja written
Salman
by
Rushdie.
Tasneem. What Tasneem? Mirza Tasneem. What is the name? Tabassum Tasneem, Bangladesh writer.
Bangladesh. Yes, sir.
So, when the ladies' chartist layers is banned over there, and if a person is selling, he cannot say that, sir, I did not know, I don't have a criminal intention, and I did not see what is inside. But you know that you are selling the book which is banned over there, and hence the mischief rule can be applied over there. And the appellant could not see and read all the book content. The argument rejected by the Supreme Court held that there was no ambiguity in the language of enactment. The meaning of section 292 is a clear and precise. The mischief of sale of obscene literature was sought to be remedied by the provisions, and therefore the interpretation given the appellant was unacceptable. Means the appellant has given the Ranji Judici given the I did not see what is inside the book. I did not go through the book. But when it is banned over there, you are not supposed to sell the book. Is it clear?
Though is illiterate. Though is illiterate.
Though he is illiterate, he is uneducated. సపోజ్ నేను చెప్పాను కదండి ఆ గాంజా చరసి హిరాయింది అరే ఇది గోధుమ పిండి రా దగ్గర ఉంచుకోరా నేను రేపు వచ్చి తీసుకుపోతా నీకు ₹1,00,000 ఇస్తా గోధుమ పిండికి ఎవడన్నా ₹1,00,000 ఇస్తాడా అండి
Very good.
అదే 1 కిలో
That you will know.
సార్ నేను చదవలేదు సార్ దాన్ని టేస్ట్ చేయలేదు సార్ వాడు చెప్పిండు కాబట్టి నేను పెట్టుకున్నా సార్ గోధుమ పిండి అని మీరు వచ్చి పట్టుకున్నారు సార్ కెన్ యూ టేక్ ద డిఫెన్స్
No, you cannot.
you cannot take the defense like that because you will be one of the member in that abetting such a thing and you will be penalized and you will come under the psychopathic substance because that is a contraband which is banned over there. You are not supposed to bring it with you. Even by mistakenly somebody is put in your pocket also.
So dunya is not that much fool.
ఎస్ అది పిల్లి అనుకుంటదంట సార్ కళ్ళు మూసుకునేది తాగుతా ఉంటే నన్ను ఎవరు చూడలేదు అనుకుంటదంట సో you will be held responsible because you are supposed to know when it is banned you are not supposed to sell such a book. Next case law is Parelal versus Mahadev Ramachandra, AR 1974, Supreme Court 228. It is a charge under the Prevention of Food Adulteration Act 1954 was brought against the appellant for selling and keeping of the sale of supari, which was sweetened with a banned artificial sweetener. ఆ ఆర్టిఫిషియల్ స్వీటనర్ ని బ్యాన్ చేశారండి కానీ ఆ సుపారీ మ్యానుఫ్యాక్చర్ లో అదే యూజ్ చేస్తున్నాడు కాబట్టి ఏంది ప్రివెన్షన్ ఆఫ్ అడల్టరీ శాఖ లో బుక్ చేశారు వీడంటాడు కదా సుపారీ ఈజ్ నాట్ ఏ ఫుడ్ he argued the appellant argued that supari was not a food within the meaning of the act. The Supreme Court rejected the argument, held that the supari is an article of food. The reason is it is sweetened with that it is sweetened which is banned by the artificial sweetener and hence you have committed an offense. The Supreme Court emphasized that the word food should be interpreted in the context of the mischief with the Prevention of Food Adulteration Act 1954. They said it is anything eaten by the mouth. Anything it is eaten or it is swallowing by the mouth is said to be a food. It is said to be the food. And that food which is manufactured with the what? Banned sweetener. And hence you have committed the mistake, you have committed an offense and you will booked under it. And hence we treat the sweetened supari as a food here. So that is the case law which is happened over there. Then he cannot say that, sir, it is a supari, it is not a food. So that is the rule applicable over there. Then another case law here also we will given, that is Kanwar Singh versus Delhi administration. Kanwar Singh versus Delhi administration, and this case law it is clearly mentioned that the Delhi Corporation Act 1902 and round up cattle grazing on the government land, that is the Municipal Corporation of Delhi, and where his Karwan Singh's cattle also seized. But Karwan Singh said, my cattle is not abundant cattle because my cattle is having a patta, a belt in their neck, and hence it's not abundant cattle. He took it, the defense. But the court consider either is the patta is there or belt is there or not. It is grazing on the municipal corporation Delhi land and which is abundant, we taken it. And which is unattended also will be said to be abundant because it is unattended. And the Kumar Singh that the word abundant means the loss of ownership, he said. But the cattle which were round up belonged to him and hence was not abundant, he said, Kumar Singh. The court held that mischief rule had to be applied. The word abundant must be interpreted to mean let loose or left unattended. Abundant means not the ownerless. Abundant means let loose or left unattended. And even the temporary loss of ownership would be covered as abundant. Is it clear? Say, is it clear?
Yes, sir. Yes, sir. Yes, yes, sir.
అబాండెంట్ అంటే అర్థం ఏ మాత్రం వదిలిపెట్టిన అన్అటెండ్ ఉన్న అబాండెండే ఈవెన్ దో దెర్ ఇస్ ఎ బెల్ట్ అరౌండ్ దర్ నెక్ ఈవెన్ దో దెర్ ఇస్ ఎ బెల్ అరౌండ్ ద నెక్ ఈవెన్ దో because you are unattended and left loose and is grazing in the municipal corporation land and hence they will be seized, they will be come under the Delhi Corporation Act of 1902. It will automatically come. Then the next case law is Regional Provident Fund Commissioner versus Sri Krishna Manufacturing Company AR 1962 SC 1526. ఈ దొరగారికి ఏమున్నాయండి 4 ఫ్యాక్టరీలు ఉన్నాయి. ఈత ఏం చేసిండు ఒక్కొక్క ఫ్యాక్టరీలా ఒక 10 మందిని పెట్టిండు. ఎటు చూసినా 50 మంది కన్నా మొత్తం అయితే లేరు అని అట్లా చూసిండు. అయితే నౌ హీస్ కమ్స్ ఓవర్ దేర్. హీస్ what is the provident fund? If a person employs more than 50 workers employees, then the provident fund is must. Correct, Andy?
Yes, sir.
Yes. So he is having the 4 units. One of us paddy mill, other 3 consider flour mill, one is the sawmill, another copper sheet mill. Kabatti 4 mills unnai. The number of employees there are more than 50.
Sir, one doubt, sir, one doubt.
Yes.
Actually, if it is machine driven, we are even for employing 10 people, he has to pay the PF. That's why
Okay.
it seems that this fellow he has bifurcated all his factors into 4 or 5.
వాడు ఏం చేసిండంటే అతి తెలివి ఉపయోగించి 4 యూనిట్ల డివిజన్ చేసిండు.
చేసి 10 బోలా 10 పెట్టిండు దాంట్లో వాడు.
అట్లా పెట్టి 50 క్రాసర్ కాలే కదా అంటాడు. ఓవరాల్ చేసిపోయిండు. నో.
He's the owner.
It is the number of employees there were more than 50 when you group together.
Yes, sir.
At that time you cannot take the plea. You cannot take the plea that it is less than 50 number. Hence, Employees Provident Fund Act 1952 because it is a run under the same banner. Even though there are the 4 different units are there.
Same employer.
Same employer. Employer is the same, but the employees are different over there. At the time they say, even though it is not crossed the 50 in each one, but you are supposed to pay the employment because all 4 unit you are the employer, hence the provident fund will be applicable because total will put together is more than 50. So the person concerned segregated the entire factory into 4 separate units wherein the number of the employees had fallen below the 50 and he argued that the provisions were not applicable to him because the number is more than 50 in each unit. ఇందులో more than 50 యూనిట్లో లేదు కాబట్టి it was held that the court had the mischief rule and had to be applied and all the 4 units must be taken together as one industry and therefore is one employer and henceforth the applicability of the PF was upheld. Yes. Any explanation you needed for this regard?
No, sir.
Please. So, Regional Provident Fund Commissioner versus Sri Krishna Manufacturing, at the time, they put together and they are the one employer and which are more than 50 members. Hence, the mischief rule can be used over there and it will be applicable. The PFA will be applicable. So, this is the some more case law where I want to share it. Yes. Is there anything, any doubt would be there? You can ask me. And here I am giving the another thing which I want to share with you. Yes. See, Mischief Rule, I already told you though, the Hidden's rule is there and mischief will be made. Of course, 4 points or 5 points will be considered. Here can I see another case? See. In other words, see the tongue. Number one, what was the law before the statute? Hidden's rule. What was the wrong with that law? How did the parliament intend to correct this? Apply the statute in that context. Adi mischief rule annattu. See, what is the hidden meaning there? What is meant actually? అరే వాసన వస్తుంది నీవు సాక్షులు పట్టుకురావు యాక్చువల్ అది మెంట్ బట్ నాట్ ఇన్ ద పాకెట్ యూ షుడ్ హావ్ టు లీవ్ అవుట్ దేర్ ఓన్లీ సో దట్ ఈస్ యాక్చువల్లీ ద కాంటెక్స్ట్ డిమాండ్ ఇట్ వాట్ ద కాంటెక్స్ట్ డిమాండ్ you have to leave your slippers, you have to leave your footwear, you have to leave your any other things in the outside only. That is the context demand. So let me see the difference between the rule. Let us see if any new case law is given over there. Yes, the new case law has come over there. So, of course, easy case. Smith versus Hux case law, same. Street Offences Act, we read it. Either the prostitutes, they are standing on the road or on the street, or they are standing on their own house, or standing on the balcony. Standing is not more important, soliciting is the more important. So some of the prostitutes were accused of soliciting the contrary to the act. The defendant, along with the other prostitute, sat on the balcony inside the building, tapping the windows and attract the attention of the men and the street. Applying the literary rule, will the defendant will be guilty of soliciting? No. They applying the only mischief rule, then only the prostitutes are held liable. This Crockery versus Carpenter, already we have seen this case law. And Elliott versus Gray also, that this case law also we have seen it. Then, yeah, there is a continuation. Of course, he has given the drawing, but only one case law which is not covered over there is the first one. That is the case law. Megar and Saint Melan RDC versus Newport Corporation 1950. The law Denning case law that we have not studied. That we see that we sit here to find out the intention of the parliament and of the ministers and carry it out. We do this better by filing the gap and making sense of the enactment than by opening it up with the destructive analysis. So what is the gap would be there that we would like to fill the gap, that is the mischief, and draw the remedy for that. What do you think that meant by this one? It was better to interpret the statute in a way which carries our parliamentary intention than to be so restricted by the exact wording that is not achieved. In contrast, Fisher versus Bell, where the purpose of the legislation was to prevent the sale of the offensive weapons, was defeated. The court have been seen on occasion to go out of their way to enable the statute to work. So, what is that actually? The mischief will be suppressed, the remedy should have to come out. That is the whole gist of this case now. Yes, now the time is 12:15. If anything that you would like to ask me, you can ask me and I will give the explanation for that one. Says, today we have covered the mischief rule is there, but tomorrow is a Sunday, there is no class tomorrow. Let you enjoy the Sunday with your family, doing the household work and helping the people and pampering their family. Then take them to the vacation. Of course, if the corona is there, now we cannot do so. Yes, anything that you would like to ask me, you can ask me now.
Thank you, sir. Thank you very much, sir. Thank you very much.
So
Everything
the
okay.
point is
Clear,
the
clear.
point. Yes, yes. The next class, what we will see it, purposive rule is there, or we can say harmonizing is there, or beneficial legislation is there. So that we will see it on Monday most probably. And regarding the exams are concerned, whether the exams are there may not be there, doesn't matter. Knowledge will not go waste. What do you say?
Sir, the more the time we get now, with the more we will imbibe the knowledge.
Knowledge, and we will make the perfect. That is the reason practice makes man perfect. With
Perfect.
this, I will stop it. End of the meeting and stop sharing. And have a good day
Thank you, sir.
and goodbye. Then end of the meeting for all. Yes.